Hello everyone, I am Advocate Uttam Dubey and welcome to our channel law&u. Today we will be talking about culpable homicide and murder. We are making this video in two parts. पहले video में we will only focus on the definition, that is section 299 and section 300, and part 2 of this video, in that we will deal with section 302 and section 304 जहाँ पे इसके punishing sections हैं ये. Before we start with this series, we have to understand one basic thing. What is homicide? Homicide means killing of a man by a man. That is a human being killing a human being. The word side, we have heard it many times. We heard it as pesticide, suicide, germicide. Side basically means killing. So what does homicide stands for? Homicide दो वर्ड से बनता है, दो Latin word. The first one being homa and the second word being side. ये दोनों वर्ड को कंपाउंड बना के इसका मीनिंग है किलिंग ऑफ ए ह्यूमन बीइंग बाय ए ह्यूमन बीइंग. दिस इज द डेफिनेशन ऑफ होमिसाइड. नाउ द क्वेश्चन इज, अगर आपसे किसी की डेथ हो जाती है या फिर कोई किसी को मार देता है, इज दैट एन ऑफेंस? एंड द आंसर टू इट इज नो, इट इज नॉट एन ऑफेंस. इट विल बी ओनली एन ऑफेंस if it falls under section 299 and section 300 of the Indian Penal Code, because killing of a man can be for legal reasons as well. Now the question is, how can you kill someone and then say it was justified or it was legal to kill him? अपने Indian Penal Code में there is a provision. Homicide can be of two types. Firstly legal and second illegal. The lawful homicide, the legal homicide, is provided under chapter 4 of the Indian Penal Code. It starts from section 76 up till section 106. These are the legal reasons for killing a human being. Now what are unlawful homicide? Unlawful homicides are of four types. The first one being culpable homicide not amounting to murder, which is provided under section 299. The second one being murder itself, that is provided under section 300. The third being rash and negligent homicide, which is provided in section 304. And the fourth one being suicide, which is provided under section 306. Now the question is, how will you remember कि section 300 stands for murder and section 299 stands for culpable homicide? Because the definition is very similar in nature. It is the definition of murder is just expanded definition of culpable homicide. So not to create any confusion, the difference, how to remember section 299 is culpable homicide and section 300 is murder. When we look at section 300, it is 300. The 3 can be seen as M. Therefore, it is easier to remember that section 300 stands for murder in the Indian Penal Code. Now the culpable homicide. Culpable homicide, why it is called as culpable homicide and not just as homicide? Culpable means blameworthy. आप किसी को उसके लिए responsible बोलते हैं कि you have caused his death and you are responsible for the same, therefore you should be punished. That is the reason the word culpable is being used. अगर culpable नहीं है and it is just a homicide and it falls under exceptions of which is provided under part 4 of the Indian Penal Code, then it is not an offense. To make something fall under section 299, it has to be culpable in nature and all the ingredients of section 299 have to be present in the same. Now coming to section 299. Section 299 reads as, whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with the knowledge that he is likely by such act to cause death commits the offense of culpable homicide. This is the definition of culpable homicide and it also has 3 explanations for the same. Now when we read the definition of culpable homicide, 4 चीजें होना बहुत important है. Firstly, causing of death of a human being. So what does it say? When you kill a human being, then only it will be a homicide, या फिर आप उनको punish कर सकते हैं under section 299. If it is killing of an animal, then protections are provided in other legislation. It cannot be said that the offense be punishable under section 299. The main 2 ingredient under section 299 is that death has to be caused. वहाँ पे death होना बहुत ज़रूरी है and it should be death of a human being. Now along with this, what are 3 main things which has to be present here? Other 3 conditions are act with intention of causing death, an act with intention of causing such bodily injury as is likely to cause death, and act with the knowledge that it is likely to cause death. Now when we look at this, intention and knowledge are the dominant factor over here. When you have intention to kill someone, or when you have knowledge that your act may kill someone, then it falls under section 299. Therefore, intention and knowledge are the two basic and two main ingredients to charge someone for culpable homicide. Now, in this relation, we have one judgment of the Supreme Court, which is Arun Nivalji More versus State of Maharashtra. It says that if the offense is such which is covered by one of the clauses, but does not fall within the ambit of clauses firstly to fourthly of section 300. In section 300 we have 4 clauses which we will come later in the same video, and if does not fall under these clauses, it will not be murder and the offender would be liable to be convicted under section 302. In such a case, if the offense is such which is covered by clause 1 or 2, now what is 1 or 2? 1 or 2, it talks about intention. The offender would be liable to be convicted under section 304 of the Indian Penal Code, as it uses the expression if the act by which the death is caused is done with the intention of causing death or of causing such bodily injury as is likely to cause death, where intention is the dominant factor. However, if the offense is such which is covered by clause 3, the offender would be liable to be convicted under section 304 part 2 of the IPC, because the use of the expression if the act is done with the knowledge that it is likely to cause death but without any intention to cause death or to cause such bodily injury as is likely to cause death, where knowledge is the dominant factor. Now, why there is a difference between knowledge and intention? जब हम बोलते हैं intention means you want to kill that person, you have intention of killing that person, but you say if you have knowledge, you are just aware that it may result in his death. So this is the basic difference between knowledge and intention. Therefore, अगर आपको किसी को मारने का intention है, then it is an offense and you will be punishable as per section 304 part 1, which has higher degree of punishment. But if you only have knowledge, you don't have intention to kill that person, you will be punished under section 304 part 2, which has lesser degree of punishment. So this is the difference between knowledge and intention. Now this is the Venn diagram which we have prepared. I'll come to it at the end of the lecture why this diagram is important. Now coming to the first explanation of section 299. Now the first explanation of section 299 states a person who causes bodily injury to another who is laboring under disorder, disease or body infirmity and thereby accelerates the death of that other person shall be deemed to have caused his death. Now if someone is having some disease or disorder and you are aware about it and you have intention to cause his death and you do some act which results in his death, then you will fall under explanation 1. Now when we talk about explanation 1, it straightly says अगर आप किसी की death accelerate करते हैं, it is culpable homicide, but it cannot be read in isolation. It has to be read with section 299, the main definition. What are the main ingredient of section 299? Knowledge and intention. अगर आपका नॉलेज नहीं है या फिर आपके इंटेंशन नहीं है टू किल दैट पर्सन, बट बाय मिस्टेक आप उसकी डेथ एक्सेलरेट कर देते हैं जिससे वो मर जाता है, it won't fall under section 299 because knowledge and intention are the dominant factor. Now when we look at the case law, that is आइदो बेग, ये केस लॉ में एक हस्बैंड वाइफ में झगड़ा होता है, हस्बैंड अपनी वाइफ को मार देता है जोर से, जिसके वजह से वाइफ को वॉमिटिंग होती है एंड शी स्टार्ट्स ब्लीडिंग एंड एवरीथिंग एंड शी इवेंचुअली डाइज. In this case, the court said no, he was not having intention, neither he was having any knowledge that एक फिस्ट ब्लो से या फिर एक बार मार देने से कोई मर सकता है. So in this situation, he was convicted only for grievous hurt. Now when we talk about explanation 2, explanation 2 is very peculiar in nature. Explanation 2 does not say that this thing will fall under culpable homicide. It says that the defense कि उसको मेडिकल ट्रीटमेंट मिल सकती थी, उसकी तबीयत ठीक हो सकती थी, वो नहीं मरता अगर उसे प्रॉपर मेडिकल ट्रीटमेंट मिलता, is not an excuse. If that person dies, you will be held liable for it, and you will be punished according to section 299. Now what this explanation say, where death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused the death, although by resorting to proper remedies and skillful treatment the death might have been prevented. The case law in this is Silapan versus State of Tamil Nadu. In this case, एक आदमी दूसरे आदमी को मारता है, that person gets hospitalized and eventually dies. And the defense of the person, the defense of the accused was, अगर उसे proper treatment मिलती तो बच सकता था. The court said, no, this is not an offense and it falls under explanation 2 of section 299. Therefore, section 299 explanation 2 leaves no room for discussion or gives any defense to the accused कि अगर उसे proper medical treatment मिलती तो बच जाता. No, this is not an excuse. Now if we go further, third explanation, causing of death of child in mother's womb. Now explanation 3 talks about death of a child in mother's womb. Explanation 3 straight away says that causing of death of a child in mother's womb is not homicide, but it may amount to culpable homicide to cause the death of living child if any part of the child has been brought forth, though the child may not have breathed or been completely born. Now what this explanation says, अगर कोई बच्चा मदर के वूम में है एंड उसकी डेथ कॉज की जाती है एंड दैट चाइल्ड डाइज, वो होमिसाइड नहीं है, वो मर्डर भी नहीं है, वो सेक्शन 299 और 300 में फॉल नहीं करेगा. When any part of the child comes into existence, when any part of the child has been brought forth, though the child may not have breathed or been completely born, then it will fall under culpable homicide. Now the issue is, why this distinction? Why a child in the womb is not treated as a human being? Because a child in the womb cannot be said as a human being. Until unless that child comes into existence, till then it cannot be said कि वो human being है. Human beings are beings who are on earth, on the planet. The child is in the womb. Though destruction of the child or killing that child in the womb will be punishable as miscarriage of pregnancy or any other law for the time being in force. So, but it won't be punishable under section 299. Now coming to the main section, murder. Now murder is defined under section 300 और मैंने पहले ही बताया है how to remember that 300 stands for murder because 300 has 3 and 3 looks like M. Therefore 300 stands for murder. Now when we read this definition, this definition starts with except in the cases hereinafter accepted. This definition starts with an exceptional clause कि ये सारे exceptions हैं, ये सारे ना हो, then it will be murder and all these ingredients have to be present. Now when this definition starts, it says culpable homicide is murder. It does not define murder in isolation. It says culpable homicide is murder. That means in order to say anything as murder, in order to get any offense under this section, first you have to prove that that section has ingredient of culpable homicide, because until or unless it is culpable homicide, it cannot be murder. Now if we see the Venn diagram, why this Venn diagram is important over here. Now when we look at this Venn diagram, it says culpable homicide and murder. Now to understand this, we can also call it, suppose we call it as fruit and we call this as mango. Now mango is a fruit, but आप fruits को mango नहीं बोल सकते हो, क्योंकि fruits के अलग अलग क्राइटेरियाज हैं एंड अगर ये क्राइटेरियाज फुलफिल होते हैं तो मैंगो का फ्रूट बुलाते हो. लेकिन अगर आपको बोलना है कि मैंगो को ही आज मैं सारे फ्रूट को मैंगो बोलना चालू कर दूंगा, नहीं, ऐसा नहीं है. आपको ये मैंगो प्रूव करने के लिए उसके स्पेशल कैरेक्टरिस्टिक्स दिखाने होंगे कि वो फ्रूट से अलग कैसे है. दैट इज द सेम थिंग हैपनिंग इन कल्पेबल होमिसाइड एंड मर्डर. ऑल कल्पेबल होमिसाइड कैन नॉट बी टर्म्ड एज मर्डर, वेयर अगर आप मर्डर बोलते हो तो वो ऑटोमेटिकली कल्पेबल होमिसाइड है, because until or unless you are held culpable for killing that person, you cannot be held for murder. So that is the reason when section 300 starts, it says culpable homicide is murder if the act by which the death is caused is done with intention of causing death. Okay, this is the same as like culpable homicide. Now secondly, if it is done with intention of causing such bodily injury as the offender knows to be likely to cause death of the person to whom the harm is caused. Okay, even this was present in culpable homicide, but it has more ingredients now. If it is done with the intention of causing such bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Or fourthly, if the person committing the act knows that it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death and commits such act without any excuse for incurring the risk for causing death or such injury as aforesaid. So अगर हम ये definition पढ़ते हैं, so it is nothing but expanded form of expanded definition of culpable homicide. Culpable homicide में और additional ingredients डाल दिए गए so that you can filter culpable homicide from murder. This is where the distinction lies. Though we will have another video on distinction, but this is what the main distinction is. आप किसी की death cause करते हैं and it is likely he may die, it is culpable homicide. But आप किसी का death cause करते हैं and you know surely that that person is going to die, then it is murder. This is the entire distinction between culpable homicide and murder, and it can be seen from the probability of the death being caused. Now, we have already seen that all the ingredients of culpable homicide have to be present in order to charge someone with murder. But now, as we read firstly, secondly, thirdly and fourthly, we will go through it one by one. Now the firstly the clause 1, it says act by which death is caused is done with the intention of causing death. Now this is simple. Intention of causing death, you take a gun, आप किसी को point blank पे रखिए, shoot कर दीजिए. It is intention of causing death. This is murder. This is clear cut case of murder. Now coming to clause 1 of this definition, act by which the death is caused is done with intention of causing death. Now there is an act, there is death, and there is intention of causing death. Now 3 ingredients are present, but यहाँ पे जो intention है, इसकी degree बहुत high है. It has mens rea. Until or unless there is actus reus and there is mens rea, they cannot be murder. Actus reus means guilty act and mens rea means guilty intention. So until or unless there is actus reus and mens rea, it cannot be called as murder. And in murder, the degree of mens rea is very high, and it should not fall under the exceptions provided in section 300, and it should also not fall under exceptions provided in part 4 of the Indian Penal Code. Then it is murder. The case law in this is Rajesh Kumar Singh versus State. Now in this case, the accused without any provocation, जो एक exception है, without any instigation, but the deceased repeatedly attacked thrice on vital parts of body of the deceased with intention to cause his death. In this case, it was held, yes, it is murder. यहाँ पे intention भी है, यहाँ पे unreasonable degree है किसी को मारने के लिए, then it will fall under section 302, it will fall under section 300 and punishable under section 302. Now this was held proper. Now coming to second one, with the intention of causing such bodily injury as the offender knows to be likely to cause death. Second, with the intention of causing such bodily injury as the offender knows to be likely to cause death. It is same as section 299, but here the knowledge, you have more degree of knowledge. You have knowledge that it will result into his death. Therefore, it will fall under section 300 and the person will be punishable under section 302. Now this is applicable in other situations as well. जैसे I have knowledge कि किसी को spleen का problem है, उसे enlarged spleen है, and मैं जानबूझ के उसके spleen पे मार देता हूँ to cause his death. Now I am accelerating his death and I am aware that he is going to die just by my one fist blow, which in ordinary situation किसी की death नहीं cause करेगा. In this situation, I will be punishable under section 302 and it will fall under section 300. Now coming to the third part of the section 300, that if it is done with the intention of causing bodily injury or to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Now, if any bodily injury is caused and I have intention to cause this bodily injury which is sufficient to cause someone's death, this will also fall under section 300. In order to bring culpable homicide under section 300, it has to be shown that the injury which is inflicted वो इस नेचर का है कि वो डेथ कॉज करेगा, इट इज सफिशिएंट टू कॉज डेथ. फॉर एग्जाम्पल, इफ आई हैव अ नाइफ और मैं नाइफ से किसी के हाथ पे मार देता हूँ, ही इज नॉट गोइंग टू डाई, इट इज नॉट सफिशिएंट फॉर हिज डेथ. बट इफ आई टेक द सेम नाइफ एंड आई स्लिट हिज थ्रोट, दैट पर्सन इज गोइंग टू डाई. This is the difference. This is what it wants to say, that it is sufficient कि वो मर जाएगा उससे. So this is the example for it. Now coming to the case law in this is state of Karnataka versus Shiva Lingayya. In this case, the accused squeezed the testicle of the deceased, because of which deceased को heart attack आया and he passed away. Now the prosecution was of the opinion this is murder, because this was sufficient to cause his death. But the Supreme Court said no, this cannot be said as murder, though ये grievous hurt के 8th part में fall करेगा under section 320 and punished him under section 324, because the opinion of the Supreme Court is that squeezing of testicle cannot be sufficient to kill someone. He was not aware that he might end up killing that man and that person will get heart attack because of the pain which he suffered. Therefore, it is not sufficient. Therefore, the ingredient of section 300 and section 299 are not met, and the person cannot be punished under section 302, though he was punished for grievous hurt only. Now coming to clause 4. Now clause 4 says, if the person committing the act knows that it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury. That means it is imminently dangerous, the act of the accused is imminently dangerous and it has high probability that the death will be caused. So it will be assumed that he is aware कि इतने imminently dangerous act से किसी की death cause होगी, and he will fall under this clause of section 300 and he will be punished for section 302. For an example, एक market है, बहुत भीड़ है वहाँ पे, शाम का टाइम है, मार्केट है, बहुत भीड़ है वहाँ पे, कोई टैंक लेके जाता है और सीधा शूट कर देता है. It is imminently dangerous. It can be presumed, it has to be presumed that that person had knowledge कि मर जाएगा कोई इससे. Then he will be charged for section 300. There are 5 exceptions to section 300. The first one being grave and sudden provocation. आप किसी को grave and sudden provocation देते हैं and because of that he causes your death, then it will fall under exception to section 300. The landmark case in this is K.M. Nanavati versus State of Maharashtra, जिस पे मूवी भी बनी है रुस्तम. सो दैट इज़ द लैंडमार्क केस. उसमें गाइडलाइंस दिए गए थे, उसमें पूरा डेफिनेशन बताया गया था कि ग्रेव एंड सडन प्रोवोकेशन क्या होता है. इट हैज़ टू कम फ्रॉम द अदर पर्सन. इट्स नॉट लाइक आप ही जाके किसी को प्रोवोक कर रहे हैं, फिर आपको उसने प्रोवोक किया, फिर आपने उसे मार दिया एंड यू देन प्लीड दैट इट फॉल्स अंडर एक्सेप्शन. दैट इज़ नॉट अलाउड. इट हैज़ टू बी ग्रेव एंड इट हैज़ टू बी सडन, दैट यू लूज योर conscience, you lose your self-control and you end up killing that person. The second one being private defense. Now, the private defense, the offender, the accused, in exercise of his private defense, वो किसी को मार देता है by exceeding his private defense right, then it will not fall under section 300, but whereas it will be culpable homicide. Now, but the condition for private defense is it has to be without any provocation, that आपने कोई provoke नहीं किया हो उसको आपको मारने के लिए, जिसमें आप self defense अपना use कर रहे हैं. It should not be premeditated and without any intention of doing more harm than necessary for such self defense. Now what it says, there should be no provocation. Like मैं कहीं पे जाऊँ, किसी को कुछ बोलूँ, provoke करो ताकि वो मुझे मारे या फिर मुझे कुछ बोले और उस पर मैं उसे मार दूँ, then I say that I was exercising my right to private defense, self-defense. It is not accepted. और it should not be premeditated, कि आप गन लेके जा रहे हैं, आप किसी से झगड़ा कर लेते हैं, फिर वो आदमी आपको मारने के लिए आता है तो आप गन निकाल के शूट कर देते हैं. That means you want to kill that person. And the same thing also, the same example can also be taken without any intention of doing more harm than necessary for such self-defense. Now the third one being public servant. Now a public servant acting in discharge of his duty, or any person aiding a public servant, has caused death in such a due discharge without any ill will towards the victim and has acted in good faith. So अगर public servant अपना duty discharge कर रहे हैं without any ill will and he's discharging his duty according to the law and causes someone's death, then it won't be murder. Then the fourth one being sudden fight. The death is caused during a sudden fight in heat of passion without the offender having acted in unusually cruel manner or having taken undue advantage. Now what is sudden fight? आपकी किसी से sudden fight हो जाती है और आप किसी का डेथ कॉज कर देते हैं, इट वोंट फॉल अंडर सेक्शन 300 बिकॉज सपोज ए एंड बी का सडन फाइट हो जाता है, ए बी को मार देता है और फिर उसके लिम्स जो है वो कट कर देता है और फिर उसे फेंक देता है. नाउ व्हाट इज द सिचुएशन ओवर हियर? इट इज क्रूअल इन नेचर, ही इज टेकिंग अनड्यू एडवांटेज. वो सडन फाइट से अपने आप को बचा के निकल सकता था, बट वो अनड्यू एडवांटेज लेके उसका इंटेंशन, नॉलेज, सारी चीज़ें प्रूव कर रही हैं. देयरफॉर ही वोंट बी एबल टू टेक द बेनिफिट ऑफ द एक्सेप्शन प्रोवाइडेड अंडर सेक्शन 300. नाउ देयर आफ्टर कम्स कंसेंट. नाउ कंसेंट, in consent, the culpable homicide is not murder when the person whose death is caused, being above the age of 18 years, suffers death or takes the risk of death with his own consent. Now in this situation, the age of the deceased should be more than 18 years and there should be free consent. There should not be any inducement, there should not be any influence, there should not be any coercion. It should be a free consent in which the victim, the deceased, gives consent for his death and eventually that person dies. Then it will fall under the exception. And after this, there is distinction which we will discuss in the next lecture. So to conclude, section 299 defines culpable homicide, section 300 defines murder. In order to charge someone for murder, ingredient of section 299 has to be present. Until or unless it is culpable homicide, it cannot be murder. Now why distinction is required? Now the distinction between culpable homicide and murder is required because the gravity, the punishment for being provided ranges from 2 years to death. So if the gravity or intention, if the knowledge is not evaluated properly, जिसको 2 साल की भी सज़ा हो सकती थी, उसे आप directly death देंगे. And if a person dies, there is no status quo ante. It is beyond human power to make that person alive. Therefore, this distinction is very important, and that is the reason why the distinction is being drawn through various judgments and even in the Indian Penal Code. We will meet in the next session. Meanwhile, if you have any doubt, please ask us in the comment box. Thank you so much. Let's meet in the next class.